Are all California beaches truly public by law? Imagine walking along a beautiful California shoreline, feeling the sand between your toes, and wondering if you have the right to be there. Well, in California, the rules about beach access are a bit more complicated than they seem. You might think all beaches are open to everyone, but the truth is more nuanced. In California, the public has a legal right to access all beaches below the mean high tide line. That means the wet sand and the ocean itself are public property, guaranteed by the California Coastal Act of 1976. This law was created to protect the coastline and make sure everyone can enjoy the beach, even if private land borders the shoreline. However, the dry sand area above the mean high tide line can be a different story. This part of the beach might be inside private property boundaries, depending on land deeds. If a homeowner owns the land up to the high tide line, they can technically own the dry sand in front of their house. That means walking on that dry sand could be considered trespassing unless there's a public access easement or a long-standing public use recognized by courts. The California Coastal Commission, which oversees coastal development, requires local governments to include public access in their coastal plans. They also prohibit property owners from blocking access to the beach below the high tide line. This has led to legal battles, especially in famous spots like Martins Beach and Lunada Bay, where courts have sided with the public's right to access the coast. To ensure access, the Coastal Commission can require new developments to offer offers to dedicate, or ODDs. These are public easements across private land that, if accepted by a public agency or nonprofit, guarantee access paths or stairways to the beach. But if no such offer is made or accepted, and no public access existed before, landowners can legally block access to the dry sand above the tide line. So, the big picture is that all beaches below the high tide line are public by law. But the dry sand above that line can be private, depending on land ownership and public easements. This creates some strange situations where you might be legally trespassing on dry sand in front of a mansion but still have the right to walk freely on the wet sand below the tide line. Enforcement can be tricky too. Some wealthy landowners have faced fines for blocking access, but disputes still happen. The Coastal Commission works to keep access open by installing signs, building stairways, and working with agencies to maintain paths. Still, the system isn't perfect. In short, while California law makes the beaches below the high tide line public, the dry sand above can be private property unless public access has been legally established. This mix of public and private rights along the coast makes California beaches one of the most interesting and sometimes confusing places for beachgoer. It's a perfect example of how laws and geography can create some of the quirkiest coastal situations in the country.